Hello, this is the second in a series of vlogs about competition litigation. The title of this second vlog is Choose Your Battles. Whether a claimant or defendant in a competition-related damages claim, you need to choose and know your opponents. First, from the claimant's perspective, the question is whether you want to sue one party which has been addressed by a commission decision or a group of such addressees. The advantage of addressing just one party is that it will lead to lower costs. However, there are a number of potential disadvantages. These include the fact that you're running a risk if the claimant against which you bring the claim, the defendant against which you bring the claim has particular defences, which means that it's not liable or not liable jointly and severally for the total amount of the claim. Also, they may not have the financial security of all of the addressees. Suing all of the addressees or a larger group has the disadvantage of being more costly. You have court costs which are multiplied by the number of defendants, and also you have to, as a claimant, respond to the arguments of each of the defendants in turn. The advantage of bringing a case against a number of defendants is that those defendants will have their interests aligned as concerns settlement, so you're more likely to be able to reach a settlement. And then from the defendant's perspective, you'll want to bring third-party claims against all of the addressees of the commission decision. But that doesn't mean that these parties should be seen as opponents. Yeah, you have to work with these parties, in fact, to be able to bring your own defence. Their defences will be relevant to your defence in the main proceedings. From the perspective of both the claimant and the defendant, it's important that you know your counterparties. Do they have external litigation funding? Do they have other commercial interests which could be influenced by the outcome of the case? How have they dealt with previous or parallel proceedings? This is likely to give insight into how the settlement negotiations are likely to proceed. It helps in determining your own procedural strategy.